Mr. Baucus. Mr. Baucus. Aye. Mrs. McCaskill. Mrs. McCaskill. Aye. Mr. Udall of Colorado. Mr. Udall of Colorado. Aye. Mr. Harkin. Mr. Harkin. Aye. Ms. Landrieu. Ms. Landrieu. Aye. Mrs. Feinstein. Mrs. Feinstein. Aye.
Wishing to vote or change their vote? On this, the ayes are 51, the nays are 47. The motion to table is agreed to. Under the previous order, the Senate will proceed to the consideration of the following measure, which the clerk will report.
H.R. 514, an act to extend expiring provisions of the USA Patriot Improvement and Reauthorization Act of 2005, and so forth.
Under the previous order, the substitute amendment is agreed to, and there will be 30 minutes equally divided for debate prior to a vote.
Mr. President.
The Senator, the Assistant Majority Leader.
Mr. President.
Senator will suspend. We have order. The Senate will come to order. The Assistant Majority Leader.
Mr. President, in a few minutes we're going to vote on a 3-month extension of the expiring provisions of the Patriot Act. I'll support this extension because it gives the Senate time to properly consider this critically important legislation. But before I support any additional extensions of the Patriot Act, I believe that we should have an honest discussion about changes and reforms that are necessary to protect the constitutional rights of innocent Americans. It's worth taking a moment to reflect on the history of the Patriot Act. The Patriot Act was passed almost 10 years ago after the 9/11 terrorist attack. Ground Zero was still burning when President Bush asked Congress to give him new authority to fight terrorism. Congress responded, passing the Patriot Act by an overwhelming bipartisan vote, including my own. It was a unique moment in our history. But even then, many were concerned that the Patriot Act might go too far when it came to our constitutional rights and freedoms. As a result, we put an insurance policy in the law, a sunset clause on the Patriot Act's most controversial provisions. I believe that was a thoughtful move on the part of the Senate and the House. We knew that we were in a very emotional state because of the dramatic loss of life and fear that followed after the attacks on 9/11. We wanted to reflect on some of the changes in authority given to the government at a later time. I voted for the Patriot Act, but I soon realized that it gave too much power to the government in some areas without judicial and congressional oversight. And so 2 years after the Patriot Act became law, I led a bipartisan group of senators to introduce the SAFE Act, legislation to reform the Patriot Act. The SAFE Act was supported not only by the American Civil Liberties Union, but also by the American Conservative Union and Gun Owners of America. It was an extraordinary coalition. Progressive Democrats and conservative Republicans came together across the partisan divide with the understanding that Americans believe we can be both safe and free. We wanted to retain the expanded powers of the Patriot Act, but place some reasonable limits on those powers within the bounds of the Constitution.
Not in order. Senate is not in order. Please take your conversations out of the Senate.
Mr. President, in 2005, the first time Congress reauthorized the Patriot Act, some reforms from the SAFE Act were included in the bill. Many were not. So there's still significant provisions in the Patriot Act which cause concern to this senator. The FBI is still permitted to obtain a John Doe roving wiretap that does not identify the person or the phone that will be wiretapped. In other words, the FBI can obtain a wiretap without telling a court whom they want to wiretap or where they want to place the wiretap itself. And in garden variety criminal cases, the FBI is still permitted to conduct what's known as sneak and peek searches of a home without notifying the homeowner about the search until some later time. We now know the vast majority of sneak and peek searches take place in cases that don't involve terrorism in any way. A national security letter, or NSL, is a form of administrative subpoena issued by the FBI. We often hear NSLs compared to grand jury subpoenas, but unlike a grand jury subpoena, a national security letter is issued without the approval of a grand jury or even a prosecutor. And unlike the grand jury subpoena, the recipient of the national security letter is subject to a gag order at the FBI's discretion. The Patriot Act greatly expanded the FBI's authority to issue NSLs, and NSL now allows the FBI to obtain sensitive personal information about innocent Americans, including library records, medical records, gun records, and phone records, even when there's no connection whatsoever to a suspected terrorist or spy. The Justice Department's Inspector General concluded that this standard, quote, can be easily satisfied, close quote. This could lead to government fishing expeditions that target, unfortunately, innocent Americans. For years, we've been told there's no reason to be concerned about this broad grant of power to the FBI. In 2003, Attorney General Ashcroft testified to the Judiciary Committee that librarians raised concern about the Patriot Act were, quote, hysterics, in the Attorney General's words, and that, quote, the Department of Justice has neither the staffing, the time, nor the inclination to monitor the reading habits of Americans. But we now know, many years later, the FBI has in fact issued national security letters for the library records of innocent Americans. For years, we were told the FBI was not abusing this broad grant of power, but in 2007, the Justice Department's own Inspector General concluded the FBI was guilty of, quote, widespread and serious misuse, end of quote, of the National Security Letter Authority, and failed to report those abuses to Congress and a White House Oversight Board. The Inspector General reported that the number of NSL requests has increased exponentially from about 8,500 the year before the enactment of Patriot Act to an average of more than 47,000 per year, and that even these numbers were significantly understated due to flaws in the FBI database. Mr. President, I believe America can be both safe and free. We can retain the expanded powers of the Patriot Act, but place some reasonable limit on them within our Constitution. I'll support this extension so we have time to produce legislation we can all be proud of. And I know the chairman of the Senate Judiciary Committee is on the floor to speak, and I want to close by saluting him. I think he has taken a very professional approach to this. He has been completely open to the discussion of the provisions of this bill and the offering of amendments. I plan to work with him and other members of the committee in good faith. I think this 3-month extension will give us a time to expand the debate on this important constitutional issue, and I yield the floor.
Mr. President.
Senator from Vermont.
Mr. President, I thank the distinguished senator from Illinois for his comments, and I will put my full statement on the record. I do want to thank the two leaders for working out
Without objection.
This extension. It includes a number of additional ideas that we did in our bill on January 26, where we do have before us the bill we did on January 26, which included suggestions to distinguish Republican deputy leader and others. We have important sunset provisions, and I will, whatever we end up with, must have these sunset provisions. I think the Republican leader, Dick Armey, was absolutely correct when he recommended them in 2001. The only reason we're going to find if things are misused, similar to what's been stated here, is if we have these sunset provisions, because it forces us to do the kind of oversight we need. So I know other senators are waiting for the floor. As I said, I put my full statement on the record, but oversight and sunset provisions are critical. I yield the floor.
The senator from Kentucky.
I want to thank the majority leader for agreeing to allow a debate on this important legislation. We will have time to amend it in the next 3 months, discuss it fully. When the Patriot Act was passed in the first place, it was passed in a hurry, without committee hearings, and in a climate of fear and anger after 9/11. Congress was sensitive to the fact that the Fourth Amendment was being abridged, and that's why these legislative proposals were sunsetted. It wasn't just so we could pass them by unanimous consent without voting. It was done so we could review how well we're doing with these and whether or not we are abridging the freedoms guaranteed under the Fourth Amendment. There are a couple things that really bother me about the Patriot Act. Number one, the national security letters. These have been mentioned previously, and I think the points are well taken. Some try to argue, oh, these are simply subpoenas, so you can do anything you want. I think they're searches of private records and should be reviewed by a judge. But even if you argued that they were subpoenas, if you have a subpoena, your lawyer is allowed to make a motion to quash your subpoena. Your lawyer is allowed to represent you. In the craziness after 9/11, when the Patriot Act was passed, it was actually illegal to consult an attorney. If you were given a national security letter saying you were being investigated, you could go to jail for 5 years by telling your attorney. It's still in the law that you can go to jail for 5 years if you tell others. This is being done against U.S. citizens. Many people argue for this saying, oh, it's just foreign terrorists. National security letters have been written on 200,000 individuals, over 50% of them from the U.S. in the last 10 years. In addition to the national security letters, this act expanded the use of what are called suspicious activity reports, where they snoop in your bank records. Not only does the government snoop in your bank records, they force the banks to do snooping for you. 2 million records have gone through. And we say, well, are we getting terrorists? Yes, we're probably getting terrorists. But were we capturing terrorists under FISA when we had a judge's review? Yes, it was very rare that FISA ever turned down a warrant. But we just gave up. We blankly gave up the idea of judicial review. This was a big deal. John Adams said that this was the spark that got the revolution going when James Otis was talking about writs of assistance in the 1760s. The king was granting writs of assistance through his soldiers. Now we have essentially government agents akin to soldiers writing warrants. It's rife for abuse. Even the FBI, when they did their own internal investigation of the national security letters, they reviewed 1,000 of these national security letters, and they found that 10% of them were in error. The other thing for those who say, oh, this is just a subpoena, it's just your bank records, no big deal, should be wary of this. People have gone through the FISA court and been turned down under Section 215 and not gotten a warrant, and they've done an end around and gone to get national security letters. I think it's something so basic to our constitutional republic. You know, I tell people on and on, I'm a big defender of the Second Amendment, but you can't have the Second Amendment unless you defend the First Amendment. You can't have the Second Amendment unless you defend the Fourth Amendment. We need to defend the right to be free of search and seizure. People need to look back and say, did the FISA court work? The FISA court rarely turned anything down as far as getting warrants, but at the very least there was independent judicial review, which is a very important part of our historical jurisprudence and I think should be guarded and protected. I think in the fear after 9/11, we didn't debate these things fully. I think we should have a debate. And there's a wide range of people on both the left and the right who do believe in civil liberties. I think it's time we do review these. I will stand up in the next several months and try to promote the discussion of this. And I think it's a good time to review and revisit the Patriot Act. I will vote against the extension of the Patriot Act because I don't think that it is doing full justice to the Fourth Amendment, and I think it's very important that we have judicial review before we allow government to investigate and search our private lives. Thank you, and I yield back.
Mr. President.
The Senator from California.
Mr. President, I asked to speak for 10 minutes.
Without objection.
Thank you, Mr. President. Mr. President, I come to the floor as the chair of the Intelligence Committee of the Senate and also as a member of the Judiciary Committee. So I've been part of the Patriot Act and the FISA Act discussions. Let me clear one thing up for the distinguished senator from Kentucky. Nothing in what is before us today affects the national security letter sections of the Act. Let me repeat that. Because I've heard this presented on the floor, I've seen it in editorials in the newspapers, and nothing in what is on the floor today affects the NSL sections, which is more than one, of the Patriot Act. There are 3 specific sections that are affected, and I will get to them in a moment. Let me begin by saying that I support the Reed-McConnell amendment to the House Resolution 514. And let me point out that last Wednesday, the Secretary of Homeland Security, Janet Napolitano, testified before the House Homeland Security Committee. And here's what she said. In some ways, the threat today may be at its most heightened state since the attacks nearly 10 years ago. In testimony to the House Intelligence Committee last week, the Director of National Intelligence, James Clapper, wrote that it is impossible to rank, in terms of long-term importance, the numerous potential threats to United States national security. The United States no longer faces, as in the Cold War, one dominant threat. Rather, it is the multiplicity and interconnectedness of potential threats and the actors behind them that constitute our biggest challenge. So it is clear, Mr. President, that the threat against the United States from terrorism, cyber attacks, the proliferation of weapons of mass destruction, and others, is at a very high level. Intelligence is our best tool in keeping America secure. And I see this intelligence day after day after day. The Intelligence Committee hears testimony week after week after week. And I believe all members of the Intelligence Committee are solidly behind the Reid-McConnell bill. So that's the framework in which these three expiring provisions come before us. Without them, our law enforcement and intelligence agencies would lack important tools to protect this nation. These are tools that have been used to great advantage over the past several years. Let me talk about the business records section that is expiring. This authority allows the government to go to the Foreign Intelligence Surveillance Act Court, a special court appointed by the Chief Justice that deals only with these matters, meets 24/7. Anybody to use the business records section must get a warrant to obtain these records. I can't speak here of the specific uses of this authority for reasons of classification. The Director of National Intelligence, the Director of the FBI, and the Director of the NSA described to members last night how this has been used. They noted, and I quote from last night, quote, "We have seen recent successful disruptions of terrorist plots directed against the United States. Our intelligence and law enforcement personnel were able to disrupt Al-Qaeda's Nasrallah Zazi terrorist plot to attack New York City's subway system. These Patriot Act authorities, along with other critical intelligence tools, are essential to our ability to detect and disrupt such plots," end quote. The second expiring provision, so-called roving wiretap authority, provides the government with needed flexibility in conducting electronic surveillance. We all know that there are now throwaway cell phones. We have found that terrorists have attempted to evade surveillance by using these throwaway cell phones and rapidly switching cell phones. This tool allows for surveillance on a particular target, not the telephone. And again, you need to have that authority given to you, much as you would in a wiretap by a court, in this case, the Foreign Intelligence Surveillance Court. And again, the surveillance is foreign. According to FBI Director Bob Mueller, this provision has been used more than 190 times since it was authorized in 2001. The third section, the final one, is the lone wolf authority that allows for court-ordered collection against non-U.S. persons who engage in international terrorism, but for whom an association with a specific international terrorist group has not yet been determined. This provision was enacted in light of the Zacarias Moussaoui case, in which the FBI suspected Moussaoui of engaging in terrorist activity and believed that at the time that it could not obtain a FISA order, in other words, a FISA warrant, for lack of definitive connection to a known foreign terrorist organization. I see Senator Kyle on the floor. He well knows this issue. So this is a specific addition that was put in because of the Moussaoui case to get at someone who is a lone wolf who has no association with a terrorist operation. These tools have been authorized for several years and have been subject to strict scrutiny by the Foreign Intelligence Surveillance Act Court, the Department of Justice, and the Congressional Intelligence and Judiciary Committees. Now, members have raised concerns that provisions authorized by the Patriot Act have been misused. The Judiciary and the Intelligence Committee have held numerous hearings on this topic. I believe past problems have been addressed, and we will continue to monitor the use of these provisions carefully. Members have also noted past problems with the use of national security letters, and that's what all the discussion so far that I have heard on the floor has been. And as I've said, the national security sections are not at issue at this time. So it is, in a sense, a shibboleth to raise them here. It's business records, it's lone wolf, and it's roving wiretaps. Those are the three sections that expire on the 28th of February. So let me be clear. This legislation does not address national security letter authorities, as those provisions are not set to expire at the end of the month. Now, by extending these three provisions until May 27th, the Congress can appropriately study them, and I hope enact the long-term reauthorizations that the intelligence community and law enforcement need to continue to keep us safe. And let me just say, Mr. President, I see and cannot go into here, but day after day uses of these sections, and have come to believe that being able to have good intelligence is what prevents a New York subway attack. It's what keeps this homeland safe, and it's what allows us to get ahead of a terrorist attack. Without them, we put our nation in jeopardy. And I, for one, took an oath of office to protect and defend, and I do not intend to be party to that. Everything I know indicates that there is jeopardy facing this nation. And these intelligence provisions are necessary to protect our homeland. I urge acceptance of the Reed-McConnell legislation, and I thank the President. I yield the floor.
Senator from Arizona.
Mr. President, I want to agree with the comments made by our colleague from California, the chairman of the Intelligence Committee, and urge all of our colleagues in the time that will exist between now and the time that we are able to take this matter up again to accept her invitation to be briefed and to appreciate some of the things that our intelligence community goes through in order to try to protect the American citizens. The points she made are all valid from my service on the Intelligence Committee. I'm aware of what she's been talking about. And I would just like to repeat three things. I won't bother to go into all of the detail because she made the points very, very well. But roving wiretaps, the name doesn't sound very good, but roving wiretaps are simply the recognition that today you have a lot of throwaway cell phones. It used to be you had one telephone hanging up in the kitchen or someplace, and so when the police got a warrant to tap your telephone, that was the only phone you had. Now, these guys take phones, use them once, throw them away, and then get another one. Or they have access to lots of different phones. It's simply a recognition that today people use lots of different phones rather than one, and therefore the warrant applies to any of the phones of a particular individual. The lone wolf terrorist exception, Senator Feinstein explained very well. I wrote that provision. And it applies to people who don't have a card in their wallet that says, I belong to Al-Qaeda, or I belong to some other terrorist group. We understood that in some cases there will be people like Moussaoui that you're not sure they are actually affiliated with any particular group, but they're still planning a terrorist activity, and therefore you want the ability to check them out. And third is the business records, and this is really the only one that there's been any controversy about. It allows the government to get a court order to obtain business records that are either held or generated by third parties. You want to find out, for example, if Mohammed Atta stayed at the such-and-such motel the night before he went to the airport to conduct the terrorist attacks of 9/11. That will help to prove the chain of evidence to prosecute other people or for us to be able to know exactly how that attack occurred. So you go to the motel and say, could we see who checked in last night? I mean, that is not a big deal. Now, for most agencies of the federal government, you don't even have to go to court to ask the question. But out of an abundance of caution here, before the government can actually go to the motel and say, can we see a record, they have to go to court to get approval to do that. So the Patriot Act and terrorism investigations. In addition to that, there are only 3 top officials at the FBI that are authorized to request a court order for the information. So the point here is this. These are the only 3 provisions that are sunsetted and that we have to reauthorize. If people have objections to other parts of the Act, such as has been expressed here, then their argument is not with the reauthorization of these 3 provisions, but with the underlying law. In any event, I suppose they'll have plenty of time to raise those questions when we debate this further in the next couple of months. But I urge my colleagues to support the short-term extension, and in the meantime, prior to the rest of the debate that we have, to check with the folks at the Intelligence Committee who can answer any questions that they may have about how this act is intended to operate, and then check with the FBI and other law enforcement officials to see how it works in its operation.
The Senator from Montana.
I'd ask unanimous consent for 3 minutes.
Without objection.
Mr. President, Montana sent me to the U.S. Senate to bring accountability to this body, to make responsible decisions and to protect America and the freedoms that we all enjoy. I took the oath of office to defend the Constitution. That's why I'm going to vote against the Patriot Act and encourage others to follow suit. I have never liked the Patriot Act. I still don't. Like Real ID, the Patriot Act invades the privacy of law-abiding citizens and it tramples on our constitutional rights. We need to find a balance, making our country more secure and giving our troops, law enforcement, and intelligence agents the tools necessary to get the job done, but we have to do it without invading the privacy of law-abiding Americans. This extension doesn't address any of those concerns. It simply puts off the debate that we need to have for another day. There are some really troubling things that would be not addressed by the extension of this vote. Roving wiretaps, which allow surveillance of a type of person instead of a particular person over multiple phone lines. That is a slippery slope to eroding our constitutional protection against government searches. Using the unreasonable grounds of suspicion standard to require libraries and businesses to report to the government about what American citizens buy or borrow. We don't have to sacrifice our privacy and lose control of our personal information in order to be secure. And we should never give up our constitutional rights. Voting for the Patriot Act is the wrong way to go. Mr. President, we've got a lot of smart people in this body. We can develop the policies that we need necessary to find terrorists without compromising our constitutional civil liberties. I ask my colleagues to join me in voting against extending this law today and into the future. I yield the floor.
The clerk will call the roll.
Mr. Akaka.
Senator from Michigan.
Mr. President, I ask unanimous consent that further proceedings under the quorum call be dispensed with.
Without objection.
Mr. President, I think all time has either been yielded back or all time is up, so I would ask for the yeas and nays.
Is there sufficient second? There appears to be. The clerk will call the roll.
Mr. Akaka, Mr. Alexander, Ms. Ayotte, Mr. Barrasso, Mr. Baucus, Mr. Beckich, Mr. Bennett, Mr. Bingaman, Mr. Blumenthal, Mr. Blunt, Mr. Bozeman, Mrs. Boxer, Mr. Brown of Massachusetts, Mr. Brown of Ohio, Mr. Burr, Ms. Cantwell, Mr. Cardin, Mr. Carper, Mr. Casey, Mr. Chambliss, Mr. Coates, Mr. Coburn, Mr. Cochran, Ms. Collins, Mr. Conrad, Mr. Coons, Mr. Corker, Mr. Cornyn, Mr. Crapo, Mr. Dement, Mr. Durbin, Mr. Ensign, Mr. Enzi, Mrs. Feinstein. Mr. Franken, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Mrs. Hagan, Mr. Harkin, Mr. Hatch, Mr. Hoven, Mrs. Hutchison, Mr. Inhofe, Mr. Inhofe, Mr. Inouye, Mr. Isaacson, Mr. Johans, Mr. Johnson of Wisconsin, Mr. Johnson of South Dakota, Mr. Kerry, Mr. Kirk, Ms. Klobuchar, Mr. Cole, Mr. Kyle, Ms. Landrieu, Mr. Lautenberg, Mr. Leahy, Mr. Lee, Mr. Levin, Mr. Lieberman, Mr. Lugar, Mr. Manchin, Mr. McCain, Mrs. McCaskill, Mr. McConnell, Mr. Menendez, Mr. Merkley, Ms. Mikulski, Mr. Moran, Ms. Murkowski, Mrs. Murray, Mr. Nelson of Nebraska, Mr. Nelson of Florida, Mr. Paul, Mr. Portman, Mr. Pryor, Mr. Reed of Rhode Island, Mr. Reed of Nevada, Mr. Risch, Mr. Roberts, Mr. Rockefeller, Mr. Rubio, Mr. Sanders, Mr. Schumer, Mr. Sessions, Mrs. Shaheen, Mr. Shelby, Ms. Snow, Ms. Stabenow, Mr. Tester, Mr. Thune, Mr. Toomey, Mr. Udall of Colorado, Mr. Udall of New Mexico, Mr. Vitter, Mr. Warner, Mr. Webb, Mr. Whitehouse, Mr. Wicker, Mr. Wyden. Senators voting in the affirmative: Boxer, Cardin, Coates, Coburn, Coons, Corker, Crapo, Ensign, Feinstein, Inouye, Isaacson, Johans, Landrieu, Lieberman, Rubio, Schumer, Warner, and Webb. Senators voting in the negative: Paul and Tester. Mr. Roberts, aye. Mr. Kyle, aye. Mr. Inhofe. Mr. Inhofe, aye. Ms. Collins. Ms. Collins, aye. Mr. Franken. Mr. Franken, aye.
I think I heard Dave.
Mr. Conrad. Mr. Conrad, aye. Ms. Stabenow, aye. Mr. Bozeman, aye. Mr. Nelson? Mr. Nelson of Florida, aye. Mr. Cole? Mr. Cole, aye. Mr. Casey? Mr. Casey, aye. Mr. Cornyn, aye. Mr. Menendez? Mr. Menendez, aye. Mr. Wicker, aye. Mr. Barrasso, aye. Mr. Blunt, aye. Ms. Ayotte, aye. Mr. Levin, aye. Mrs. Gillibrand, aye. Mr. Lugar, aye. Mr. Burr. Mr. Burr, aye. Mr. Kirk, aye. Ms. Klobuchar, aye. Ms. McConnell. Mr. McConnell, aye. Mr. Vitter. Mr. Vitter, aye. Ms. Mikulski. Ms. Mikulski, aye. Mr. Blumenthal, aye. Mr. Manchin, aye. Mr. Leahy, aye. Ms. Snow, aye.
I can't find it anymore.
Mr. Alexander, aye. Mr. Bingaman, aye. Mr. Graham, aye. Mr. Brown of Massachusetts, aye. Mr. Johnson of Wisconsin, aye. Mr. McCain. Mr. McCain, aye. Mr. Akaka, aye. Mr. Sessions, aye. Mrs. Shaheen, aye. Mrs. Hagan. Mrs. Hagan, aye.
Kathy?
Mr. Johnson, South Dakota, aye. Mr. Sanders, no. Mr. Grassley? Mr. Grassley, aye. Mr. Lautenberg? Mr. Lautenberg, aye. Mr. Brown? Mr. Brown of Ohio, no. Mr. Whitehouse? Mr. Whitehouse, aye. Mr. Cochran? Mr. Cochran, aye. Mrs. McCaskill, aye. Mr. Reed of Rhode Island, aye. Mr. Dement? Mr. Dement, aye. Mr. Lee? Mr. Lee, no.
I'm a yes. Aye.
Mr. Bennett, aye. Ms. Cantwell, aye.
Was it high school?
Mr. Hogan, aye.
Kelly,
Yes.
you got that.
Yes.
I mean, it's not like it's the most typical.
No, and it's unbelievable. It's the same.
The buttons are this.
The buttons are different.
Mr. Durbin, aye.
Yes, sir.
Mr. Shelby. Mr. Shelby, aye. Mr. Baucus. Mr. Baucus, no. Mr. Toomey. Mr. Toomey, aye. Mr. Chambliss. Mr. Chambliss, aye. Mr. Harkin? Mr. Harkin, no. Ms. Murkowski? Aye. Mr. Hatch? Aye. Mr. Enzi? Mr. Enzi? Aye. Mr. Moran? Aye. Mr. Udall of New Mexico? No. Mr. Rockefeller? Mr. Rockefeller? Aye. Mr. Nelson, Nebraska? Aye. Mr. Merkley? No. Mr. Risch? Mr. Risch? Aye. Mr. Udall of Colorado? Aye. Mr. Portman? Mr. Portman? Aye. Mr. Wyden? Aye. Mrs. Hutchison? Aye. Mr. Lautenberg? No. Mr. Bekich? No. Mr. Carper? Aye. Mr. Thune? Aye. Mrs. Murray? No. Mr. Reed of Nevada? Aye.
Any other senators wishing to vote or to change their vote? If not, the ayes are 86, the nays are 12. The bill as amended is passed.